politicians or before you become a member of any political party. The kind of things that happen in Nigeria is so obnoxious that if God looks down from heaven, you realize that we are really paying for our sins.
Speak your truth and be heard on the Eagles Morning Rise, 6 a.m. to 10 a.m. Eagles 102.3 FM. Your radio experience you can count on. From Milky Way to Earth, everywhere there's internet, you can connect with Eagles 102.3 FM Abuja. Log on to our website www.eaglesfm.com. Follow and engage with us now on Facebook, Twitter, TikTok at Eagles FM Abuja, Instagram at Eagles FM 1023. Download our apps on your Android and iOS stores. Eagles 102.3 FM Abuja, your radio experience you can count on.
So it is exactly 16th or 17th day in the month of June of 2026, and it feels good to be here again. This is politics and current affairs. That's what we'll be looking into this morning. And basically, we'll be looking into matters that concern the appeal courts stopping ADC deregistration. Judicial power, INEC, and Nigeria's 2026 or 2027 elections at stake, right? But then it also looks into matters that border around and about judges versus votes. Can your PVC survive court wars? My name is Oduak Daniel, and in the course of the discourse, I would also bring on my guest who'll be joining us via phone call. This in the person of my dear friend, brother, and resource person Benedict Olale Kongunloye is an information professional, a policy and public affairs analyst, as we go into this conversation proper, right? Might I also add that we have a website. Now, through this website, you can listen to us anywhere else that you are in the world. www.eaglesfm.com. That's what the website is. Plug in and get connected already. We also have a television right there. It's very professional. It's on YouTube, Eagles TV Abuja. On Facebook, it is Eagles FM Abuja. Get on there, show us love, show us support, and ensure that Eagles FM breathes, right? Let Eagles FM breathe. Well, that's on a lighter note. Now, on Tuesday, 16 June 2026, the Court of Appeal stopped INEC from deregistering ADC and 4 other parties. And this is after a federal high court judge totally ignored an earlier order to pause the case. So the appeal court called it judicial impertinence. They also called it rascality. Now, the 5 parties remained registered pending appeal just days before 20 June by-elections in 6 states. Now, at the heart of this is one issue. If courts don't obey each other, can you trust that your votes will count. I mean, we've seen cases in this country. In fact, it was very heated in 2024-2025. Where one court will give one order here, another court will counter there, another court will say this, another court will say that. But yes, Kekere came in aboard, and then she ensured that, well, she held a conference and called all of them together and said, we cannot continue like this. It's more like a house divided against itself. What exactly is wrong with you judges? You need to put your acts right. You need to get it right this time. Oh, just when we thought it was over. Here again we see another court verdict by a court of competent jurisdiction make a pronouncement against an earlier pronouncement by yet another court. So if this is happening within the judicial system, can you beat your chest and say my vote will count? When these judges or courts don't obey each other. So if a lower court judge ignores a higher court stop order, what does that mean for you as a Nigerian? Especially when it has to do with trust in the judiciary. Should INEC have power to deregister parties at all for any reason? And what safeguards are needed so it's not abused before elections? And then with the by-elections just around the corner on 20th of June of 2026, what happens to votes cast for parties that were almost deregistered? Some big questions right there, yeah? So I'm going to ask again this question. Like, I think this is the bone of contention here. If a judge can ignore a higher court's order and still kill 5 political parties weeks before elections, can your vote tomorrow still be safe from being cancelled by the courts today? Because there are arguments and counter arguments here and there on this same issue. And it's beginning to seem as though this trust deficit is growing into a widening margin that may not even have a resuscitation, cannot be revived, cannot be closed in no distant time. So I'm just going to let my guest come aboard now. And we will open the phone lines earlier so you can have your take in this discourse this morning. All right? Remember, it is Eagles Morning Rises Breakfast Show, and it's Eagles Outlook, where we use the Eagle's eyes to look into these issues, political, current affairs, and matters that concern you and I directly or indirectly. Hello, good morning to you, Sir Benedict.
Good morning.
Oh, welcome aboard, Sir Benedict. All right, now, here it is, what we are facing. I mean, this is a serious issue. Right? A court, or Justice Peter Lifu, had given an order to the INEC to deregister 5 political parties. Right? And now, this is against an order that had existed prior to his court ruling. And Nigerians are asking, what is this hullabaloo going on with our judicial system in this country? If you recall, 2024-2025, we saw it very heated until the coming of Kekere Justice, right? Who held a conference, called all the judges together and said, please put your acts together, put your house together. We cannot leave one order here, counter order there. It just makes everything a mess. And Nigerians have, before now, maybe we still do, believed that the judiciary or the justice system is the last hope of the common man. But can we still say that the judiciary or the justice system is the hope for the average or the common, there's no common Nigeria, of a Nigeria in this time and age? If a lower court is refusing to obey what a higher court had given as an order, can you say that we can trust the system to ensure that our votes indeed will be secured and it will count?
Well, this is my thinking and this is my opinion.
Okay.
And it is that first and foremost, we tend to have impatience when it comes to processes and procedures.
Okay.
A lot of us are not interested in regulation. A lot of us are not interested in processes. A lot of us are not interested in procedures. In the first instance, the High Court in this matter is the court of first instance, which means that whatever decision was taken at that level can be appealed against at the Court of Appeal.
Okay.
And the matter can go up until the Supreme Court. So I think that sometimes some measure of patience is required.
Okay.
And when you say the common man, many of the politicians who are with the shopping for judgment are not common man. And so they are more of the time the one throwing the entire system into confusion. And unfortunately, because a lot of people are not interested in procedure, we join their bad wagon to begin to comment and make issues. Now, I think the first thing here is this. INEC had a process that they should have run immediately after the 2023 election and tell us the outcome. Since it's in the law, Section 225 says these people have to perform to this level. I think at the end of every election cycle, it should be the duty of INEC to run that process and give their verdict and say, okay, all the parties qualify and they will continue to exist. If in the past we have used the court to order INEC to register parties, including the NDC that we have today, then if some other people are now using the same court to order INEC to deregister. Now take note, to register or deregister is the duty of INEC.
Okay.
What external forces here are bringing to play is to say, INEC, do your job in this regard. And INEC is able to say, look, I have done my job and this is the outcome of the job. If you get what I'm saying, it's not just say we've done it. There should be a result to show what INEC did after the 2023 election as a basis for why all the parties should remain. And if they have that record and they have that in place, I'm sure even now at the level of the High Court, it's just one judge that sees. But when you get to the Supreme, to the Court of Appeal, it's 3-5. And at the Supreme Court, it's 5-7. Right?
Yeah.
So if one person will not look at it dispassionately and make an error, we do not expect the 3 or 5 that will sit at the Court of Appeal to make the same error.
Right.
They would have been able to look it more balanced, and then there could be voting. Whether it's all the 3 that will support, or 2 against 1, or all the 3 will oppose. Whichever case it may be, we expect that at the level of the Court of Appeal, a better view would have been given to this matter. And I think that sometimes we need to get to that point of separating people from issues, right? So rather than all the noise of, oh, is the ruling party doing this, is the ruling party doing that? Some people went to court a month back, to order INEC to alter his timetable and allow party to wait for party submission of registers in September. Is it not?
Yeah.
And wait for candidates. So it was some people that went to court. Was it the ruling party that also sponsored them? Because that was not in any way in favor of the ruling party. But they got their ruling against INEC. So the issue here is we should take issues as issues and leave people as people. Because when you mix people and issue together, it becomes difficult sometimes to separate the right from the wrong. It becomes difficult to separate the truth from the facts.
So, Sir Benedict, let me ask you, what are the issues that we're not taking as issues, and what are the people that we are not taking as people? Maybe that can clarify better.
Fine. The issue here is simple. Somebody believes INEC has not done its job well and has gone to court to ask court to order INEC to do the job. Right? That's what the group has done. Now, if Justice Peter Leaf will have heard, the next issue should be go on appeal to the Court of Appeal. If they are not satisfied, they can continue the matter to the Supreme Court.
Right.
But all this noise, people are just making noise, comments, abusing people, insult. I don't think we need to give insult. Leave the people out of it. Focus on the issue. The issue is, has INEC done its job in the matter of party monitoring and evaluation? Yes or no? On the other part, is Justice Lifu right to have gone ahead to deliver the judgment? Possibly, I knew there had been a case in the past where was it the Court of Appeal that claimed that, look, this matter has been concluded. So, what you are now trying to do is to kidnap the judgment, right? That if we have already concluded the matter and say we should do no further proceedings, the judge might just be hiding under. I think that has been the case in the past, where I was in the Sokoto electoral gubernatorial election or something like that, about 2008, 2009. Of course, it became a big uproar where I think the Court of Appeal felt that the Supreme Court was kidnapping his judgment, that the judgment was already read. So why would you be talking about stay of proceeding? Again, when you also look at what has happened in the Court of Appeal, there is an urgent matter that some people are.
Oh, we just lost that connection right there. We will try to reconnect in a short bit. But here is the conversation already. But in case you missed it and you're just tuning in for the first time, on 5th June of 2026, right, Justice Peter Lifu of the Federal High Court in Abuja delivered a judgment ordering INEC to deregister ADC, Action People's Party, that's the APP, Action Alliance, that is the AA, Accord Party, and Zenith Labour Party, the ZLP. Now, what is the reason behind this? The reason was that they failed to meet constitutional requirements for continued existence, right? But on 22nd of May of 2026, now the Court of Appeal had already told Justice Lifu to suspend all proceedings in that case until appeals were heard. So when he ignored it and he still went on to give that judgment, the parties ran back to the Court of Appeal. So on 16 June 2026, a 3-member panel led by Justice A.B. Mohammed unanimously granted a stay of execution. So this means that the registration is paused. So the 5 parties remain registered until the appeal is decided. So the panel condemned Justice Lifu's conduct as a brazen violation of the hierarchy of the court and the 1999 Constitution, and also went further to saying that this is the highest form of judicial impertinence. In fact, they quoted the Supreme Court's precedent that a judge who acts this way is unfit for the bench, as it amounts to judicial rascality. If you ask me, these are very heavy words to say to a judge right there. Well, are you there? Can you hear me?
He did not.
Hello?
Lawyer to say,
Hello?
bring ADC court to my court.
Hello?
The case was assigned to him.
Hello?
ADC think they will not get justice?
Come on. I really wish you could listen to me, Sir Benedict. I really wish you can listen. We're just trying to reconnect with you and to get the juice of what you are saying. But I've got a call. Let's quickly take calls now. Hello, good morning.
Yeah, good morning.
Yes, good morning to you.
Yeah, my name is Honorable.
All right, talk to us, Honorable.
Seriously speaking, any judge who did not respect the higher court decision, it should be on that bench. I didn't knew that there was a appeal court, judgment, or can I say judgment or judgment, or a appeal court said they should hold down. I think that's the meaning of what the appeal court said.
That's right.
So what must, if you actually want to develop this country or obey the rules, there's no country, any society where the rules are not respected, that society will not move forward. So that judge, he should resign. The lower court board who gave this instruction a few days back. And I think he's acting, we can say, with that action, just like that, he's acting on instructions from people. So he should not be on the bench. He's not qualified to be on that bench.
Right. So do you have fears, Honorable, based on our elections now, with this kinds of confusion going on, so to speak?
The reason we are going to have the election in Nigeria, when INEC voter has already been exposed, and these are the judges out, they will be on the same judges. So what do you want to? I don't think there will be credible election in Nigeria.
Okay. All right.
Because we see in a situation where this type of judgment is passed, it's in favor of INEC. So INEC has already appointed some judges, so we're giving judges judgment in their favor. That's what it is. We need to be honest. I am not a member of any political party. Those people are affected. Rather, they will first me in the lecture. I know they are going to first me, but I have to be honest. It's there.
All right.
Let's say the truth. Let's say the truth and let the truth save us.
Great.
What we are doing is it could be our turn tomorrow.
All right. Thank you,
Look
Honorable.
at the judgment. Look at the ACT last election judgment about ACT. It is not. It has been interpreted by Supreme Court. So it's not a law.
All right, Honorable.
We can't consider this. Two back to change. The judge should not leave that thing.
Okay.
Thank you.
All right, Honorable Edwards right there. Remember, you too can add your voice in the discourse 0907-353-0044. Sir Benedict, are you there?
Yeah, I'm here.
At some point, we just kept on hearing you talk, but we needed to know from where you began so that we can have a basic understanding of what you're saying. So, if I understand you correctly, Sir B, you're saying that Nigerians are being overtly reactive to this without really looking, deeply into the matter. And if I also understand you correctly, you're saying that the Justice Peter Lifu has not done anything wrong.
No, what I'm saying is he has taken a decision which is within his power to do.
Okay.
Now, if we think he has done wrong, there is the National Judicial Institute or National Judicial Council where a petition could be sent to, and he will be properly sanctioned.
Okay.
Right?
Okay.
It is not for the press, no matter what it is, it's not for the emotional outburst. All the emotional outbursts will not make any difference. If the matter gets to the NJC and the NJC has him to defend himself and he has a point that is valid before the NJC, he will definitely be allowed to go free. But what I'm also saying is, we're talking about things that has to do with timeline. Now, in the stay of execution or stay of proceedings, as they say, came from the Court of Appeal.
Yes.
Court of Appeal has actually adjourned that hearing that interlocutory hearing has been adjourned to November. Now, if we're talking about election holding in January, and then there is a matter pending that will be determined now, or that should be determined now, you are joining it in November. If in November you now say, oh, INEC, go and deregister, right?
Yes.
You now determine the matter. So by December, if you are just asking INEC to deregister or take any decision, how does that fall within the framework of the January election? Because by November, we expect that some printing or some publishing will have been done for the 2027 election. So I think that in my own opinion, my own little opinion, I also think that somewhere along the line, Court of Appeal had not treated the matter with the seriousness that it demands. Right? A matter that affects 2027 election, you have an appeal on it, and then you are pushing it to November.
Okay.
When you are done hearing in November, if they are not pleased, maybe that matter will go to Supreme Court. When does it come back to the lower court for continuity? Then it means that you possibly now determine the matter after election.
All right,
maybe one of the parties you have to deregister had already won the election. Are you now going to say you are deregistering them? So they will now say status bar. Or they will say it's an academic exercise.
Or technicalities.
So I think that there are a lot of things we need to look at in our procedures and make demand for proactive and forward-looking decisions. But like I said, if the judge has erred, there is the NJC.
There's the NJC. Let me put a peg to your thoughts.
Emotion is not necessarily the truth.
Yeah.
Emotion is not necessarily the fact.
Okay, let's take this call.
We deal by fact.
Let's take this call.
And there is a provision for appeal.
That's right. Let's take this call already. Hello, good morning.
Yes, are you hearing me clearly? Are you there?
Yes, clearly, loudly, and clearly. Go ahead. What's your name? Where are you calling from?
Yes, this is Abuja calling for Abuja. I greet your guest here, Mr. Yudi.
Yes, please. Talk to us.
Yes, Justice Peter Lifu disqualified 5 political parties.
Indeed.
They said that they have not made up their requirements.
That's right.
Does any constitutional right give him the power to disqualify those parties, Mr. Yudi? If not, does Justice Peter Lifu to be disqualified in the judiciary system to be also disqualified? You pass exams to become a judge does not mean that you know more than any other person. You make people there in the judges system before you have become a judge. So this is a Federal Republic of Nigeria, owned by all of us, does not owned by any party. You have to be a neutral. You have to work for everybody. Qualify a judges. So you can't work for any political party. So I think it should be factual, and it should also be back in the judiciary system, because it's not a qualified. Thank you very much.
All right, many thanks for that right there. Abubakar is asking what constitutional right does Justice Peter Lifu have, in ordering the INEC to deregister political parties. Sir Benedict, I'll come back with you in a short bit. Let's just take yet another family member now. Hello, good morning.
Good morning, sir, Mr. Yudi.
Good morning to you, please. What's your name? Where you calling from?
I'm Olatunji calling from Kubwa.
All right, talk to us, Olatunji, straight to the point. Let's go.
Okay, my own take is that it's like they are correct. They are doing correction with they are correcting with what is not really right. Because it is true that the minor political parties at the eve of the election, they emerge, and which is also constituting maybe the problem to zoning, because if there are many parties, there will be a problem in how to locate zoning to the region. And again, in terms of financial instability, they will also be bribed among the people that want to contest under some parties like that. Because I want to really say, if these people can appeal this judgment and they win it, that means we need to talk to our judiciary. Maybe there should be some cases that some people are going to appeal, it must quickly be submitted instead of rather going a justice. We now make judgment on it, that we rather be appealed by the accused person or the this thing, and later won. So that means our judiciary, there are some issues that they must know that there should not be even up to the level of judgment, that maybe they should submit it to the higher court. Because if I notice one of the parties, there is a court of appeal enacted over it. Maybe I don't know the party. So that means the judiciary should already submit some cases to the higher judge, higher court, instead of rather going by any justice like Justice Nifo, which has caused something like a abnormality in the judiciary. So I see the judiciary, in the first place, they should just have a way taking some cases to the higher judge, higher court, rather than making some laws. So I see that if people can appeal it and they want it, that means they have make a funny motion that that we turn the judgment or the judiciary into a chaos and litigation.
Right.
So that's just my take.
All right, thank you, Olatunji, right there. Appreciate that from you. But we should also put it out there. I mean, Justice Peter Leafull's power came from Section 251, subsection 1 of the 1999 Constitution, not from the power to deregister by himself. And if you also recall, he gave the verdict asking INEC to deregister. He didn't say, I hereby deregister these political parties. I just want us to be clear on that. So, Section 251, subsection 1E of the Constitution of the Federal Republic of Nigeria, 1999, as amended, is section gives Federal High Courts exclusive jurisdiction over any action or proceedings for a declaration or injunction affecting the validity of any executive or administrative action or decision by the federal government or any of its agencies. Now, INEC is a federal agency. So when INEC asked the courts in 5th of June 2026 to confirm that it could deregister ADC, AA, APM, APDA, and SDP and all that under Section 225A, the Federal High Court was the right court to hear it. So probably Justice Liffle was sitting as that court. But then again, there are some concerns that still come from the place of whether or not the 3 appeal court judges have a right to put a stay of execution. Well, it does, because they also citing from Section 241 plus Section 243 of the 1999 Constitution, plus the Court of Appeal Act. I mean, that section says a lot too as well. But let me come back with you, Sir Benedict. In this type of situation, how do we reconcile? How do we reconcile so that we don't lose the trust of Nigerians? We don't lose the trust of supporters of these political parties, such that they feel as though there is a mandate to disenfranchise them from voting their desired parties or belonging to their desired parties and all. And there will not be a rift between political party actors and politicians in view of 2027.
Well, clearly put, like I stated, the issue is straight. Somebody is saying, INEC, we think you have not done your job in this area. Go and do it. It is for INEC to prove we have done our job. There is nothing more to do.
Right.
So, and that's why I said there is not much need for all the emotional outpouring and the shenanigans we are having around. A decision has been taken. There are 2 issues here. Should Peter Lifu have gone ahead, Peter Lifu has gone ahead to give a judgment based on the appeal held by a court party? That's one issue to be determined, and that's for possibly that will get to the Supreme Court before you can even or NGC before you can determine that,
right.
Because it's a case as it speaks today between the powers of the Court of Appeal and the right of the Federal High Court. That's the way I see it.
Okay.
So if it's between the 2 of them, that matter might only be resolved at the Supreme Court or by the NGC. I think that's one on one part. But on the other part, giving an order to INEC to do their job, I don't think it's wrong. It is for INEC to say this you are saying, we have already done it, and this is the result of the exercise. And I think that will put everything to rest. But if they have not, if it's not satisfied and he has given a ruling against them, they can go to the Court of Appeal and prove that, look, we have done it, and we showed him the evidence that we have done it. So there is no need for the order that he has issued. Right?
Okay.
And if that evidence is sufficient, the Court of Appeal will overrule the order and they will continue with their activity. And in which case, if they are still not, if they have, the plaintiff are still not pleased, they can proceed to the Supreme Court. But like I said, there are levels of court, and I don't believe that all our courts are compromised. Okay. No, there are men of integrity on the bench. And like I said, the High Court is just 1% that seats. 3 to 5 seats in the Court of Appeal, 5 to 7 seats in the Supreme Court. So on that basis, when you check it, you will realize that the possibility of an error getting to the top is not likely, except if the lawyers handling the matter on behalf of the defendant do not know exactly what to do. Okay. So all those saying, if there is an error in the High Court, then the judiciary is rubbish. It's a lie. That's why there are layers across the world. That's why judgment does not end at the Federal High Court. That's why you need to go to the Court of Appeal. That's why there is a Supreme Court. Okay. It's because there is the possibility of an error, there is the possibility of an oversight, and so if it happens, it is not a huge abnormality, as some are trying to paint it. Right. Students do write exams and others have to do a review. And eventually, when the review is done, there is a different result.
Okay, I beg to put a point to your thoughts right now. I've got to take a breather right now, but I'll come back with you, connect with you, and of course get to hear from family members who are already biting to add your voice in the discourse this morning. We'll be right back in a short bit. Don't go away.
Eagles 102.3 Abuja.
When President Bola Ahmed Tinubu appointed Nyesom Wike as Minister of the Federal Capital Territory in August of 2023, expectations were high. Known for his infrastructure-driven administration as Governor of Rivers State, many Nigerians wondered whether he would bring the same pace and energy to the nation's capital. Nearly 3 years later, Abuja bears visible signs of a government determined to accelerate development. From major road construction projects to urban renewal initiatives and increased budget performance, the Federal Capital Territory has witnessed significant activity under Wike's leadership. One of the most visible aspects of the administration has been its aggressive infrastructure agenda. Across Abuja, new roads have been constructed, while several abandoned projects have been revived and completed. Major road networks linking urban districts and satellite communities have improved accessibility, reduced travel times, and opened up economic opportunities for residents. Rural communities have also benefited from road projects aimed at connecting previously underserved areas to the city center. The administration has also embarked on the construction and rehabilitation of critical public facilities. Among these are the renovation of the International Conference Center, the construction of the Abuja Division of the Court of Appeal, and the development of key interchanges designed to ease traffic congestion within the city. Beyond physical infrastructure, the minister has repeatedly emphasized fiscal discipline and project delivery. According to the FCT administration, Abuja achieved between 90 and 95% implementation of its 2024 budget, a figure described as one of the highest performances in the history of the territory. The administration maintains that virtually every project captured in the budget received attention and funding. Supporters argue that this level of execution demonstrates a commitment to translating budgets into tangible projects rather than mere paperwork. Residents in several communities have acknowledged improvements in road infrastructure and access to government services. Community leaders in rural districts such as Kwali, Buari, and Gwagwalada have praised projects that have brought development closer to grassroots populations. Economic activity have also received a boost from the administration's infrastructure push. Construction projects have created jobs, stimulated local businesses, and enhanced investor confidence in Abuja's development prospects. The government has consistently maintained that infrastructure remains a key driver of economic growth and improved quality of life. There is broad acknowledgement that Abuja has experienced an unusually high volume of visible construction and infrastructure activity during this period.
On several occasions, President Bola Ahmed Tinubu has publicly commended Nyesom Wike for what he described as his commitment to project delivery, urban renewal, and the transformation of the Federal Capital Territory. During the commissioning of various projects across Abuja, the president praised the minister's drive, describing the pace of development in the FCT as evidence of purposeful leadership and effective governance. For many observers, the relationship between the president's vision for the nation's capital and the minister's execution of that vision has become one of the defining features of the current administration. Beyond Abuja, the minister's performance has also attracted attention in his home state of Rivers. Many Rivers people, community leaders, youth groups, women associations, and stakeholders have expressed pride in seeing one of their own entrusted with the responsibility of managing Nigeria's capital city. Several groups have publicly thanked President Tinubu for finding Nyesom Wike worthy of such a strategic national assignment. As the Federal Capital Territory continues its journey towards becoming a modern, efficient, and globally competitive capital city, the legacy of Nyesom Wike's tenure will likely be judged by the durability and impact of these projects in the years ahead. For now, the roads, bridges, public buildings, and renewed construction activities across Abuja stand as visible markers of an administration focused on infrastructure, execution, and transformation. This has been a documentary on the performance and achievement of the Minister of the Federal Capital Territory, Nyesom Wike, since assuming office in Abuja in 2023. Sponsored by K&K Construction Property Homes Limited and engineer Kelvin Dobbin Green and Friends.
Own a piece of Abuja today with Firth Urban Limited. We offer premium estate lands in strategic locations including Katankwe Extension, Asokoro Extension, Guzape 2, Piakasa and Koje. Our properties come with FCDA approved titles, verifiable at ages, giving you peace of mind and confidence in your investment. Enjoy flexible payment plans of up to 12 months with no hidden charges. Whether you are building your dream home or securing your future through real estate investment, Firth Urban Limited has the right property for you. Call 091-1165-8936 or call 070-7299-8350 to book a site inspection and take the first step toward owning land in Abuja. Firth Urban Limited, shaping earth, consolidating standard.
Please listen to this infomercial.
Are you looking for a solution to your borehole problems? Let me introduce you to Farex Borehole. At Farex Borehole Services, we are not just competent. We are committed to providing simple, reliable, and professional solutions to all your borehole needs. Whether you require a borehole survey, borehole drilling, or assistance with any borehole-related challenge, Farex Borehole Services is your trusted partner. Even better, you can make a 50% down payment and spread the balance conveniently over 6 months to 1 year while your borehole project is being completed. For inquiries and booking, call 080-3596-5170, 080-3596-5170, or visit our office at 3rd Avenue, Gwarimpa, behind H Medics, Abuja. Farex Borehole Services, delivering reliable water solutions with professionalism and excellence.
Things they happen for our community, eh?
Now I can recoup back all the money I have spent on this annoying family.
Hey, yeah. That woman own don't finish.
My dear, let's go and greet them, okay?
Hey! Join Media Coalition and Awareness to hold trafficking, MICAT, on I Wish I Knew radio drama and program every Saturday at 10 a.m. on Eagles 102.3 FM Abuja. Join us to kick human trafficking out of our society. I Wish I Knew radio drama and program is brought to you by MICAT and funded by the Ministry of Foreign Affairs of Denmark.
And so that conversation is still on here, and we're looking at matters that concern judicial judgments and verdicts that have been put out there. And as it concerns INEC, as it concerns you, as it concerns me, right? And we're still getting to hear from you still. I mean, you can still bring that call through. How does this affect, your thought process when it comes to the electioneering process come 2027. Honorable Edwards has said, look, as far as he's concerned, with all of these back and forth, he doesn't really see some credibility in the near future. And then some others, Olatunji has also come to, talk about, the processes and what right, what role does the judge have to indeed interfere in these matters. But then if you also look at the elongation of the judgment till November, it makes you also wonder whether the justice system in the country is indeed, for lack of words, is in tandem, is in line, is awoken, is woke to the realities and the importance or what 2027 election really means to Nigerians. Because when you put you adjourn a ruling that is supposed to be determinant of whether certain political parties are fit or unfit for a general elections that's just around the corner, you adjourn it to November. What exactly are you telling Nigerians here? How much time would you have to give the political parties and say, okay, I think after everything, due diligence and everything, we are instructing the INEC now, you can deregister these parties. And you don't think that there's going to be a lot of litigations, a lot of court processes, a lot of confusion here and there? And then how do you think the political parties will even take it? I mean, is it not better for them to know earlier than to wait up until November? And, the guest also made something clear. So what if one of the candidates wins, one of the candidates from these political party wins? Are you going to also say, well, because we've deregistered you, it means that your party candidate cannot win? Or we've deregistered the winner of the elections too. I mean, so it brings a lot of chaos. But then again, the constitutional right, the 3 appeal court judges had to put a stay of execution comes from Section 241 plus Section 243 of the 1999 Constitution, and it also is in tandem with the Court of Appeal Act. And that section says, a party can appeal to the Court of Appeal from decisions of the Federal High Court as of right in certain cases, including final decisions. Now, ADC and others appealed the June 5, 2026 Federal High Court judgment. Once an appeal is filed, the Court of Appeal becomes the senior court over that case. Now, Section 243, subsection 1 now is saying the Court of Appeal has the power to affirm, vary, or set aside any decision appealed from the Federal High Court. To do that properly, the court must first freeze the lower court's order so it doesn't cause damage while the appeal is pending. So the freeze is called a stay of execution. So the actual law backing the stay of execution, Order 4, Rule 9 of the Court of Appeal Rules 2021 and Section 15 of the Court of Appeal Act. Now this rule, or these rules say, the Court of Appeal may order a stay of execution of any judgment pending the determination of the appeal. Now the 3 judges on 22nd of May 2026 used this power when ADC said, if INEC deregisters us now, the appeal will be useless because we'll already be dead. So maybe I can build a little bit of an example for you, right? Imagine you lose a match and say, I want a rematch. The senior referee, that is the Court of Appeal, says, okay, we'll review the replay. Now, while reviewing, he tells the junior referee, that's the Federal High Court now, don't delete his player account yet. That don't delete yet is stay of execution. So if junior referee deletes the account before replay finishes, the rematch becomes useless. Maybe that really sends the message. But let's get back with our guest, and you two can put that call through. Remember, you can indeed leave a message in the message, comment section on Facebook. Now, there's a live television going on there on Facebook, Eagles FM Abuja. On YouTube, it is Eagles TV Abuja. And we have the website. It is www.eaglesfm.com. That's how you can connect with us. So I'll take a couple of messages as your calls come through. Right, I see this one here now. Okay. All right, BB, I see your message. She's sending a message to each and every one of us saying, let's be careful along the Kogi roadways because of the dangers that might be there. But anyways, thank you, BB, for that. Now, let's get to Yusuf. Yusuf, all the way from Wuse 2 now. So Yusuf is saying, good morning to you, UD, and your guest. Good morning to you. On the issue of Court of Appeal, ruling on ADC and others, your guest has explained the hierarchy of courts and have advised Nigerians to be patient for processes to run up to Supreme Court instead of criticizing Justice Peter Lifu. I disagree with him because what we are concerned with is the abuse of court process, not the process itself. Now, if courts are silently helping politicians to reshaping rules and narrowing the political space few months to elections, we have the right to complain. What we are seeing is that Supreme Court will rule and the lower court will overrule the Supreme Court and ask you to start the process back to the Supreme Court. In the process, they churn out all manner of contradictory and vindictive rulings. The NJC should step in and do the needful because the confidence in the judiciary has waned or way down despite charges quarters commission by Wike recently. He says, have a nice day. And I'll take this one here as we get to hear from you in a short bit, Sir Benedict. This one is coming from whom now? It's coming from my dear friend and brother, Yunus Anthony Ibrahim, right? Now, all the way from Abaji, by the way. It says, it is disheartening for both INEC and judiciary to continue putting Nigerians in a limbo. Two judgments can't be passed at the same time. The judgment of Justice Peter to deregister other parties is mutually dependent, while the justification of his court is to be submissive to the Court of Appeals since the case is already in the Court of Appeals. Two judgments should not be mutually independent. The status of the higher court should be acknowledged. Then, for Justice Peter's judgment is unfair and biased. He should remember that only him can't dictate how elections should go. And this should be done in accordance to the rule of law. I appeal. He should understand that democracy is a sensitive area that needs to be wisely checkmated. This can cause a lot of shenanigans within INEC, government, and judiciary because it is a sensitive area that deals with candidates with followers. With the loss of trust by Nigerian citizens on INEC, government, and judiciary, I don't think we should problematize what is not a problem to avoid a quest of disintegration of unity in our democracy system. In conclusion, even if many parties contest, one party must be the winner. So let's take things easy and do the right thing for the the interest of free, fair, and credible elections. Thank you, Eunice said right there. Well, let's get your parting thoughts, Sir B.
Well, I will still insist. In my opinion, procedures should be allowed to follow. And reporting any erring judge to the NJC is also part of procedures. So, insisting whatever all of us say on the street has no effect on what would happen inside the courtroom. Now, why the Superior Court has the power to take their decision as a Superior Court, I also think that they should be looking at expediency. Like I said, a court has raised an appeal on this matter.
Yes.
Court of Appeal has fixed the hearing for November. Now, the person who is talking, will he be happy that these matters are not determined and then the election is over and then you now say these parties are not qualified to contest the election? Then we have a Zamfara or a Bayelsa case where the winner of the election, if he's one of the parties that are not qualified to contest, is eventually disqualified. I think that would be a case of waste, because that's the way it was stated in Zamfara, that whoever voted for APC in 2019 wasted his vote. The same way in Bayelsa in 2020, whoever voted for for APC wasted their vote and the decision was taken. So I think that matters like this should be taken with expediency. The Court of Appeal should not just be granting order and deferring hearing. They should hear the matter as quickly as possible and let it be determined. So we should be talking about quick dispensation of justice. Hear the matter, determine it, and let it end there. Not give injunctions or order and then go to sleep and then we wait forever. I think that a matter such as this that has to do with election, that has to do with nomination, the court appeal should not have been set for November. Not much people is talking about that. We are just talking about if we should have kept quiet or should have done nothing. But I think that we need to rework our political jurisprudence and be sure that matters cannot be delayed for unnecessarily. Because from June or from May to November, I think that is too long a time. All the matters should be determined as quickly as possible. And that will now put the confidence of the people back in the judiciary. That if the lower court err, the upper court can always make rectification. And that the NJC is there to punish erring judgment, not newspaper articles, not individual statements. It is the NJC that has that power, and they should be allowed to do their job. So whoever felt aggrieved should write his petition and send to the NJC.
All right, many thanks though, Sir B, for that one. Very, very subjective right there. You put it out there, and we appreciate your time with us. Thank you. Right. Well, this is where very objective and very, yes, that's what it is. And he said, he kept on saying, well, my point of view. But then again, it is a conversation that's still developing. I mean, I believe we will see more, from that, from this particular angle. But then it also brings, to bear some thoughts that, hey, why wait till November? Why not settle this matter now so that every political party or each political party knows where they stand exactly? And those who are going to be voting for them will also have the time to choose whether or not the party is dead or the party is still alive as we decide come 2027. My name is Udrak Daniel. We'll go take the business news in a short bit. Thank you.
Eagles 102.3 Abuja.